I would suggest 50-50, and the court wants an evidentiary hearing. That would be fine to show this lie that now is being peddled by the plaintiff.
Guys, what starts as a routine custody motion instantly reveals a deeper power struggle. Mom steps forward, asking for sole physical and legal custody, framing the narrative around limited overnights and stability.
2024 30890 and Kathleen House versus Jonathan House. Today is Monday, December 2nd, 2024 at 9:10 a.m.
Court will note the appearance of Ms. Podolsky on behalf of the plaintiff, Mr. Bartell on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, payment of bills, and exclusive use. Ms. Podolsky.
Thank you, Your Honor. As we've stated in our motion, the defendant vacated the marital home back on April 27th of 2024. The parties have one minor child together who's 10 years old. And since leaving the home on that date, the defendant practiced very sporadic overnights and parenting time. From April 27th through November 2nd, he had 10 overnights with the minor child. This was not because my client was keeping the minor child from him. He simply was not asking for the minor child. Then he was served with the instant divorce matter on November 6, 2024, and then had 9 overnights after that because he saw the request for sole physical custody of the minor child made by my client. At this time, Your Honor, we're asking the court to issue a temporary order granting my client the sole physical and legal custody of the minor child with parenting time to be determined by the court. We believe a reasonable schedule is appropriate. This is in line with what the parties have been practicing since the defendant vacated the marital home back in April. Also, since that time, he has been contributing to the marital bills. He's been depositing paychecks and funds into the joint account, allowing my client to take care of house payments, utility payments, insurance payments, and the like, and to provide care for the minor child. We're asking the court to order that the parties continue with that status quo so she can continue to make those payments as he did vacate that marital home. He has since found a rental. In fact, it is right next door to where she is living. But we do believe it is important that he continue to maintain the status quo with her financially, as this is what the parties have been doing since separating 6 months ago. We have outlined in our motion where the parties are employed, what their income is. We believe child support should be set pursuant to the Michigan child support formula, and we're asking the court to issue this order today.
Okay, thank you. Mr. Bartell, I read your answer and you said that he was exercising 50% of the time. Was that after the November 6th date when he was served or what?
It was around that time, Your Honor, but I would like to back up. There are text messages, and I think it's a bit disingenuous for plaintiff to suggest that my client had not actually asked for more parenting time. For example, August 24th, there was text messages back and forth in which the plaintiff indicated that she would not do anything except for the weekends. My client says that's not acceptable, and I want more overnights. So my client originally was not, as we put it forth in our answer, he was trying to, I guess, not rock the boat, so to speak. Your Honor, there is actually a very close, tight-knit bond between the minor child and my client. He, every single day, Your Honor, picks up the minor child from school, and he consistently has him for at least several hours, if not until his bedtime. And, Your Honor, that has been the case since the child has been going to school. The child is almost 11 years old here in about a week. The child had a breakdown within the last couple of weeks because he's fearful that he's not going to have significant contacts with my client. My client did not want the minor child being put in the middle of this. All he said was, I'm not going anywhere. I'll be here. And he didn't want to get into the fight in court, at least the portrayal by plaintiff that he does not have significant ties with the minor child. Your Honor, my client now does have roughly about 50-50. We don't deny for a number of months there, he did not have as many overnights, and it's not because of his own choosing. It is because of plaintiff, and he didn't want to rock the boat. But let's not forget, for the first 10 and a half years plus of the minor child's life, the significant contacts and everything that my client did with and for the defendant. He is significantly involved in the minor child's school. He goes to every school event. He helps them with his homework. He just recently, Your Honor, they went hunting again, and the minor child got his first buck. That is how close of a bond they have. I would suggest they have actually a closer bond than plaintiff does with the minor child. But my client knows and recognizes, despite that, it is in the child's best interest for them to continue on with what has historically been a 50-50, at least a 50-50 arrangement will be in the best interest of the minor child going forward. With regards to the expenses, your client, now that we're in this action, I think things have changed. There is going to be child support that is going to be calculated. That is a change from what is before. Plaintiff does work. She wants to be in the house. She wants the exclusive use of the house. My client does not disagree with that and is fine with that. But she should pay for everything related to the house.
Dad pushes back firmly, highlighting daily school pickups, emotional bonding, and years of involvement. He reframes the story from absent parent to active father, demanding 50-50 and equal footing. This moment feels strategic, almost like a reset of the entire narrative. Do you believe his involvement outweighs the overnight numbers?
My client has his own place that he has to pay for, and they can be responsible for their own respective bills, such as cell phones, etc., which my client had been paying for. So we would ask for there to be joint legal and physical custody in this matter, and for there to be alternating weeks for parenting time. I would also like to note my client's parents have heavily been involved in this matter with the minor child, and I note that because there are many times, even of recent, that plaintiff is asking my client's parents to help out if they both are at work. The plaintiff went back to work approximately 4, 5, 6 weeks after she gave birth to the minor child. My client's parents watched the minor child every single day until the child went to school. Okay. And historically, like I said, since plaintiff works beyond when the pickup at school is, my client has always picked up the child, always. And we wish that for the roughly 50-50 to continue forward. That's in the best interest of the minor child. If anything, this minor child is going to be devastated if plaintiff gets her way. And there is no doubt that the minor child wants to have that significant time with my client, and that should continue forward, notwithstanding the several months that plaintiff wanted control in this matter. And it became very clear what she was doing retrospectively.
Okay, thank you. Ms. Podolsky, any response?
Thank you, Your Honor. If the defendant were concerned about the minor child's devastation, he would not have left 6 months ago and then stopped seeing him on a regular basis. Instead, as counsel stated, he didn't want to rock the boat and he didn't do anything for 6 months. Your Honor, the reason why my client was concerned about weekends and weekdays and continues to be concerned about weekdays is because the defendant works at 5:30 in the morning. On the nights when he has kept the minor child during the week, during these last 3 weeks since being served, the minor child is coming back to her, going to school cranky, moody, snarky, disrespectful to her. And that's a significant concern. That's just going to lead us down a tricky path with school. It can lead towards poor performance in school and this mood continuing in school. So we don't believe that overnights during the week would be appropriate because of that work schedule. And yes, my client does work outside of the home and has gone back to work since the minor child was born 10 and a half years ago. And we're not going to shame her for working outside of the home. The parties did use the defendant's parents as childcare, and she's continued to remain in contact with his parents. She's not divorcing them. These parties are getting divorced. She's maintained a civil relationship with them so they can continue to have a relationship with their grandson. So, Your Honor, we do believe our request is appropriate and is in line with what these parties have been practicing for the last 6 months.
Your Honor, can I just make note?
Hold on a
Oh, I'm
second.
sorry. Let's hear
Ms.
the motion.
Ms. Podolsky, do you acknowledge that the defendant has been picking up the child from school and having him each day?
He has, it's not every day. He has picked up
I
the minor
understand.
child. Yes, but yes,
Okay.
he has picked up the minor child after school.
Okay, Mr. Bartel, what else did you want to add?
I just want to briefly respond to a couple things. Number one, with regards to the teacher thing, my client last week actually, we knew this was going to be brought up. He spoke directly with the teacher, and the teacher said there has been no moodiness or change with regards to the minor child. I would suggest 50-50, and the court wants an evidentiary hearing that would be fine to show this lie that now is being peddled by the plaintiff. The child has been fine. But with regards to that, Your Honor, I would also make two notations. My client's parents, if need be, are willing to watch the child for that half hour or so while he goes to work. But the other thing I would note, Your Honor, is, this one other case I had with you about 6 years ago, you're not going to remember it, but I had a case from St. John's where the kids were coming down from St. John's to Penfield, hour 15 minutes each way, and this court didn't have a concern around the same age that they would have to be getting up about 5:30 in the morning. I would just make note of that. Finally, Your Honor, my client has been picking up the child every single day after school. Who else is? Plaintiff is working. That's just not true, Your Honor.
Okay.
And my client has consistently every single day seen the child since he's left the marital home. And
Okay. I don't need it. I don't need anything else, Mr. Bartel. Obviously, your memory is much better than mine from a case that's long ago. So I have not much recollection. In this case, however, the court does note, as acknowledged by the plaintiff, that the defendant has been picking up the child after school, having him in the evenings. So it does appear that both of the parties are heavily involved with the child, notwithstanding a period of months where, after the separation, where he maybe didn't have the child on an overnight basis. The court does believe that, based upon what's been presented at this point, that there is an established custodial environment with both parties. So what the court is going to do is grant to the parties joint legal and joint physical custody. The parenting time shall be in alternating weeks, commencing at 6:00 p.m. on Friday and then proceeding to the next Friday, with each of the parties having a midweek on the week that the other party has the child. The court would set support pursuant to the support guidelines, order that the parties would exchange all income information within 7 days of today's date so that we can have a calculation of the support. The court would grant to the plaintiff exclusive use of the home and make her responsible for all the expenses, mortgage, taxes, insurance on the home while she's in possession of that. That will be the order. Ms. Podolsky, you can prepare that and submit it under a 7-day notice.
Thank you.
Joint legal, joint physical, alternating weeks, support recalculated, home awarded, but expenses assigned. In a matter of minutes, the balance resets and neither side walks away with full control. It's a reminder that custody battles often end in structured compromise. Was this the fairest outcome possible? If this breakdown gave you clarity and insight, make sure you like the video, subscribe to the channel, and drop your thoughts below. We'll see you in the next video.